Good evening. Dear doctor friends, let me introduce myself. I'm Mrs. Isha Pavan Yaul, Head of Strategic Initiatives and Partnership of Institute of Medicine and Law. On behalf of my organization, I welcome each one of you to this webinar. Friends, every life is precious. I'm sorry, I think some problem. Friends, every life is precious. The one which can be saved and the one who saves it. Failure to protect a doctor does not bode well for anyone, neither the patient, nor the doctor, nor the nation. On 29th March 2022, India witnessed a very unfortunate event, the suicide of Dr. Archana Sharma, a gynecologist from Rajasthan. It was undoubtedly a deliberate misinterpretation of law and a definite misuse of police power. We pray that God give enough strength to her family to cope up with this difficult situation. This tragic event could have been avoided if Dr. Sharma was aware of her legal rights and privileges in a police case, which today most of the doctors in India are not. Institute of Medicine and Law is organizing this webinar to help doctors understand criminal laws applicable to medical practice, the salutary protection given to doctors in cases of criminal medical negligence, and ways and means to use this legal protection. I would now like to call Dr. Arun Kumar Sharma, Director, Medical Intensive Care Unit, Fortis Hospital, Mohali, to speak a few words regarding importance of legal education for doctors. Dr. Sharma, can you please take?
Sure. Thank you, Isha. I wish everyone a very good evening. It's my honor and privilege to be a part of this August gathering of panelists and participants. And I extend my sincere appreciation for Dr. Mishra and Mr. Bajpai for taking this initiative for raising awareness. I've been given the task of setting the context into motion and as to why we doctors should be aware about the legal aspects of medicine. Blame it on consumerism. The modern day medical practitioner no longer enjoy the trust or the faith which probably our forefathers enjoyed. The risk of litigation is something which is looming large on our head. It's an ever dangling sword. On top of it, we have scenarios where our police personnel book up cases of the doctors under the sections which invoke the crime of murder, culpable homicide, or rash and negligent act. And these actions are in direct contravention of the directions which have been given by Supreme Court. We doctors are mostly novices about the aspects of law, and it does make sense to be aware about our rights, privileges, and our statutory safeguards which have been provided to us by our judiciary. We doctors are mostly involved in our medical pursuits where we talk about patient safety, but I think it's equally important to be aware about our own safety. If we are aware about our own legal safeguards, I think the unfortunate incidents of death of Dr. Archana Sharma could have been avoided. I'm hoping that we would have great interaction during this session, and this awareness is very important for current day medical practitioner. Thank you so much.
Thank you, Dr. Sharma. I now call upon Dr. Rajesh Mishra, National President, ISCCM. Dr. Mishra is associated with us on various initiatives. I request him to please say a few words regarding this initiative, as he is the official nominee from ISCCM representing the association for the Dr. Archana Sharma MedLegal HelpDesk. Dr. Mishra, please say a few words. I think Dr. Mishra is on mute.
Okay, thank you. So, hello everyone, good evening, and I'm really thankful to Law of Institute for this initiative where they are teaching, training, and letting our doctors know that what are the criminal law, particularly criminal law, because nowadays B doctor has started getting threat from different media, different resources and different perspectives. So most of the time we are there to save life, but we all know that we cannot save all the life. But looking to the current status and current mindset of public and in general everyone, it's very important for us to protect ourselves while protecting the patient and saving the life. Particularly the law related to criminal law related to doctors are very clear. There are clear-cut Supreme Court judgment. But unfortunately, most of us are not aware about it, and many a time we become victim of something which we should not. So Institute of Law has taken a good initiative to educate our medical fraternity about this law. And Dr. Bajpai is well known for doing this cause. So I'll ask Dr. Bajpai to start his talk on this. And I wish that most of us can understand this, and this should go more and more doctors. Thank you, Dr. Bajpai. Mr. Bajpai.
Thank you, Dr. Mishra, for those kind words. I now call upon Advocate Mahendrakumar Bajpai, Advocate, Supreme Court of India, Honorary Director, Institute of Medicine and Law. Advocate Bajpai, can you please put some rays of light on this important topic?
Shall I only have to put some ray of light, or do I have to run this slide deck also?
Yes, please.
I thought you will be asking me to do that later. Honorable President of ISCCM, Dr. Rajesh Mishra, Dr. Arun Sharma, guest of honor, and my dear friends, a very good evening. Quite rightly put by Dr. Mishra, that yes, slowly things are becoming tough for doctors, and criminal laws that way is something which everyone fears. Why only doctors? If an advocate is threatened with the police case, the first thing he will try to do is try to ensure that he does not get caught, there is no case registered against him. Every other day we see some of the most powerful men of this country, the politicians, running to courts asking for anticipatory bail. The only problem that has forced us to really come on this platform and try to reach out to more and more doctors has been that unlike a common man or even an uncommon man, doctors have a very good protection in India, given by the Honorable Supreme Court. And as a student of comparative law, I always say, this protection is not given to anyone in the world. I mean, any doctor community in the world, either by a court's case or by a written law, does not enjoy this protection. You all have got such a good protection. Even after that protection, it is very natural that there will be fear, there will be stress, there will be anxiety. But yes, certainly to a larger extent, it must be addressed that yes, law is on my side. I have got legal protection. I should not fear this much. Apprehensions will always be there. On a very personal note, as not only as a good friend of Dr. Mishra, but as a president of ISCCM, he has taken this initiative and right from the first day when we came out with putting up this Dr. Archana Sharma HelpDesk, he said, no, this is a great initiative and my organization will be there. Amongst the 5 first organizations, today, right from Indian Medical Association to API, everyone is there in this initiative. But the 5 first organization, in fact, let me tell it on record that the first organization which came on board was ISCCM. The importance that Dr. Mishra has given to this initiative. So without wasting a lot of time, let us straight away go to the slide deck. understand criminal laws, understand what are the protections that are there. And all those of you who have registered, after the webinar, you all will be getting an email in which the judgment of the Supreme Court would be there. Okay. One copy of the judgment would is there with Dr. Arun Sharma also, with ISCCM members also. If you don't have the time to go through or wait for the webinar to end, please write to Dr. Arun Sharma and take a copy of that judgment. We have downloaded it from Supreme Court. We have marked the relevant portion. Always keep it in your drawer. Any point in time, any policeman, any relative of the patient tries to threaten you, show him. Hit it on his face. I have great protection. Don't try to threaten me. Legally, whatever you want to do, you please do. I will face it legally. But if you are trying to threaten me, if you are trying to coerce me, understand law is there on my side. Then you do whatever you want to do. So all those who are here, you will get it. You don't get it, Dr. Arun Mishra is Arun Sharma is there. Please get it from here. I am sharing my screen. Isha, is it visible?
Yes, now it's visible.
Okay, it is moving.
Yes.
Yes, sir.
Okay, fine. So friends, let's start. Very basic definition of what is negligence. Friends, negligence happens to be nothing more than carelessness. But carelessness of a higher degree. Or at times, when a profession like a doctor is involved, when a professional like a pilot is involved, the standard of care that you have to take is very high. You have to be more careful than the ordinary people in ordinary situation. And the reason is very obvious. There is a life on the other side. So in the common terms, in what we can understand, it is a wrong. Law considers negligence as a wrong. And negligence is one wrong which will invite both civil consequences and criminal consequences. What it means is, if you are negligent, you have caused harm to someone, the wrongdoer may be sued in a civil court, the wrongdoer can be sued in a consumer court, and a police case can also be filed against the wrongdoer. The best part or the most interesting aspect of negligence is, although it has been labeled as a crime, there is no moral fault, there is no intent in doing what the wrongdoer has done. We are careless, everyone is careless at some point in time every day. Yes, carelessness of a higher degree is negligence. Let us understand that. Let us be very clear. It invites both civil and criminal liability, but the intent, the moral fault is not there. And that is why courts are very liberal as far as negligence is concerned. The person has been punished for something that is so very natural, that has no immorality, no unethicality involved with it, no immorality. But yes, the wrongdoer has to be punished for public good. Otherwise, every negligent man would be causing a lot of harm to the society. So the law really wants you to be more careful. As far as medical negligence is concerned, this applies even to negligence done by others. But as far as criminal medical negligence is concerned, This aspect of law is absolutely clear in black and white. And what is it? It is that to invite criminal charges, the negligent act must be of the highest degree. Recklessness, gross negligence. Only then criminal charges will be attracted, not in the normal course. In the normal course, the person who has been wronged, they can approach the civil court, they can approach the medical councils, they can approach the consumer court, but not the criminal side. Because on the criminal side, if the charges have to be attracted against the doctor, it has to be gross negligence, it has to be recklessness. If recklessness is there, if gross negligence is there, criminal proceedings are in addition to civil, consumer and regulatory proceedings. That's really tragic as far as negligence goes, medical negligence goes. For one wrong, one doctor can be sued before multiple forums. And if he is grossly negligent, recklessness, then even before a criminal court. One other aspect, some of you may be practicing in 100% charitable hospitals or 100% government hospitals where you just charge a nominal fees. Now, such doctors, such hospitals cannot be sued before a consumer court. We also know this fact that 99% or even more than 99% of the patients who are dissatisfied with the medical care, they are going before consumer court. They are suing their doctors, they are suing the hospitals before a consumer court. To go before a consumer court, fee is very relevant. If you have not charged fee, if you are a charitable hospital, if you are a government hospital, patient has not paid you anything, patient can't go before the consumer court. But this dictum does not apply to criminal cases. Even if you have not charged any fee, and if you are negligent and grossly negligent or recklessness, then that patient, even that free patient who has not paid a penny, can sue you in a criminal court. So this is a mota-moti definition, description of civil and criminal liability, differences between both of them. So the take-home message here is that if there is ordinary negligence, then criminal liability will not be attracted. Let me also share with you, as a lawyer, in the cases that have been decided as far as criminal medical negligence is concerned in India, till date, and doctors are being prosecuted for criminal medical negligence right from the time of the Britishers. We have judgments of Privy Council. Doctors, only those doctors who have indulged in cross-pathy. You are a homeopath, you are Ayurvedacharya, and you indulge in allopathy practice, or outright quacks. Only they have been held negligent under the criminal laws. So, this is just to illustrate what is gross negligence, what is recklessness in the eyes of law when a medical practitioner is before the court. All other instances of negligence are negligence, maybe negligence, may not be negligence, that the civil courts will decide. But these cases do not come under the definition and description of criminal medical negligence. One more piece of information, may be interesting. Even in the case, that celebrated case where 12 crore rupees was granted compensation by the Honorable Supreme Court in a case of medical negligence, even in that case, the patient's family had approached, police filed a case against the doctors and the hospital, a criminal case. But both the Kolkata High Court as well as the Supreme Court held that in this case, you cannot charge the doctors with criminal medical negligence. They were directed to pay 12 crore rupees in the consumer court. That's a different story altogether. But although the charges were filed, or rather complaint was made against these doctors, they should be prosecuted, they should be imprisoned for causing death by negligence. Both the Kolkata High Court as well as the Honorable Apex Court was very clear in stating that no, this is not a case where criminal medical negligence can be attracted, and they were left. Friends, next, let us understand criminal liability as a whole. Yes, it is absolutely clear that causing death happens to be something that every doctor fears, and for that it is section 304A of the Indian Penal Code, under which the doctor is charged and punished. But there are other criminal provisions also, which you as a doctor, as a medical practitioner, you may attract. On a very broader scale, the sources of criminal liability that a doctor may attract while performing his or her professional duty, they come from two sources. The number one is Indian Penal Code. Nearly all the crimes, this thing would be a crime in India. You find it in Indian Penal Code, right? From a rape to murder to cheating, forgery, everything. So these are the crimes which are enumerated. Around 540 sections are there. There are special acts which also prescribe certain do's and don'ts as crimes. Now, as far as medicine is concerned, you have the PCPNDT Act. It is a special act applicable only to doctors. MTP Act applicable only to doctors. Transplantation of Human Organs Act. Some parts are applicable only to doctors. And there are provisions which fasten criminal liability on doctors. In fact, even the recently notified Surrogacy Act, Artificial Reproductive Technology Act 2021, both of them have certain provisions, criminal provisions, which a doctor can attract while performing his or her duty. One very interesting aspect, friends, and very fundamental also that you should remember. Criminal liability always arises from a written law, unlike civil liability. Something could be civil wrong. You don't need a written law to say what is a civil wrong. But for a criminal wrong, there has to be a written law. So only these laws, the provisions of law which are there in the Indian Penal Code and the special laws, depending upon your area of practice. Now, if you are a general physician, you certainly don't attract PCPNDT, MTP and Transplantation of Human Organs Act. But if you are a urologist, you certainly attract Transplantation of Human Organs Act. You have to read those acts. You have to be clear that you don't perform certain actions, because if you perform them, they are crimes under this act, and you can be prosecuted and imprisoned. As far as criminal negligence is concerned, there are 4 sections: 336, 337, 338, and 304A. A doctor who is negligent in his conduct, but ultimately he does not cause any hurt to the patient, then section 336 would be attracted. If he causes simple hurt, 337, and if he or she causes grievous hurt, 338 would be attractive. 304A is when the negligent act causes death. Friends, there are other offences also under the Indian Penal Code. One more clarification. All the provisions that we are just rushing through right now, so they are just merely of academic value, because in India, doctors have yet not been prosecuted under these provisions. But friends, as we know, every section of the society is becoming more and more regulated. Even medicine is becoming more and more regulated as we become a developed economy. Provisions which were not applicable yesterday, they may become applicable yesterday, and that is why we are just going through these provisions. So other offences are section 269 to 271. Some of these provisions were used even during this COVID pandemic. Section 274 to 276, it is regarding adulteration of drugs. Anyone found adulterating drug or using or supplying, they are prosecuted under these provisions. Section 287 is negligent conduct with respect to machinery. And today your arthroscope and endoscopes, they all are machineries. So if you are negligent in using those machineries, 287 could be attracted. Section 312 to section 318, these are regarding medical termination of pregnancy. Proper act is there. Friends, before we move on to the three very important protections that you have, the topic for which we are here, one more piece of information that would be very important for you, and that is that as far as adulteration of drugs is concerned, whenever you come across an adulterated drug, please inform police, please inform the authorities immediately, preferably in writing, and take a copy of acknowledgement and preserve it. Why? Because there is something known as a criminal procedure code. There is section 39 there. Generally, if a wrong has happened, if a crime has happened, every citizen of this country, every person of this country is bound to inform the law enforcing authorities, the policeman, that a crime has happened. But if someone, even after knowing it, does not inform the police, the responsibility to prove in the court that this person was knowing and still he did not inform the police. I'm not talking about participation. I'm just talking having knowledge of crime. And you are not informing the police. That is also a crime. Is on the police. So the policeman has to prove that, oh, look, here there was a death caused by negligence of a doctor. And when the patient came to another doctor, he did not report it to police. He ought to have reported. The police will have to prove this in the court of law. It's very tough, and generally the policemen don't apply the provisions because they know they won't be able to prove it. That Dr. A or Dr. B was really knowing that Dr. X was negligent, and still he or she did not inform the police. But that is not the case with adulteration of drugs. In adulteration of drug, every person who comes across an adulterated drug positively has to inform the police, and if he or she fails to inform the police, then this person has to prove in the court of law the justifications or why he or she could not inform the police. It's really a very onerous, a very burdensome task. So I'm not suggesting that you come across a crime, you should not inform the police. You should certainly inform the police about every crime. But yes, if you come across adulterated drugs, then certainly you have to inform immediately. Take a written acknowledgement from the policeman and do preserve it. There are other offences also which doctors may attract, and that they may not be very far. Falsification of accounts, giving inflated bills, false bills. Patients are not suing today. Tomorrow, intelligent advocate may approach a court or a police station and get an FIR registered. Even fabricating records happens to be a crime. So you have to be careful. We come to the topic of the day, the three invaluable protections which have been given to each and every doctor in India in case of criminal proceedings. Friends, this judgment was given way back in 2005. And the Honorable Supreme Court, the bench was headed by none other than the then Chief Justice of India, Justice R.C. Lahoti. He delivered the judgment. And he said, no, the doctors in this country, they need protection. The socio-economic conditions, the other factors which are there, if the doctors live constantly under the threat of criminal prosecution, it is not good. A very reasoned judgment is there. It's a big judgment. A very recent judgment given out by Justice R.C. Lahoti, why doctors must be protected from criminal prosecution. And Justice Lahoti said that we understand that lawmaking happens to be a very cumbersome procedure. Till the time law is made in this regard, the parliament applies its mind on whatever we have said on protecting the doctor. We are passing a law. And in that judgment, they protected doctors, three salutary protections. And friends, when I say salutary protections, trust me, no other profession, no other category of persons in this country has this protection. People often say that parliamentarians have great protections, no one can arrest them. Fair enough, we have seen parliamentarians getting arrested. The protection that parliamentarians and legislators of this country have is a protection which is there only for 6 months when their house is in session. And if an FIR is registered of a cognizable offence, the investigating officer simply has to write a letter to the presiding officer of the house to which that legislator or that parliamentarian belongs to get permission, and it is 2 days or 3 days, not beyond that. The parliamentarian, the legislator, he or she gets arrested. Protection is only there for 2 or 3 days, that too only 6 months when their house is in session. And you have got a protection which is running 7 days a week, 12 months a year, 24 hours. If the policeman has to proceed against you in a criminal proceeding, right from 4 months' time to 20 years, this is the time that the policeman is going to take to proceed against a doctor. A complete protection. You can approach courts, you can get anticipatory, you can ask for quashing, you can do all that is possible under the law of the land. Well protected, thanks to this judgment, Jacob Matthews versus State of Punjab. Let us understand very fundamental aspect. Most of you would be knowing. For all those who don't know, criminal proceedings in our country can be initiated in 2 places. One, in a police station, and we all know that. If there is some fight, you simply go to the police station and you lodge a complaint. Then it's up to the police to do what is required. The policeman sitting there does not hear you out. You go to a higher police official and you get the complaint registered. This is a police complaint. You also have a right to straight away go to a court of law, a criminal court, a magistrate's court, a municip's court. And there you can straight away file a complaint. This is known as a private complaint. So criminal proceedings start either in the police station or in a court of law, criminal court, a police complaint and a private complaint. Now let us see, and let me share with you. The Honorable Supreme Court has protected you at both the places, in private complaint as well as police complaint. Let us see how the protection has been given in private complaints. This is what is written in paragraph 53 of that judgment. Let us read it. Quote, a private complaint may not be entertained unless the complainant means the patient in cases of medical negligence, has produced prima facie evidence before the court in the form of a credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of the accused doctor. So if the patient goes to the court, what the Supreme Court is suggesting is that the court must ask that patient, you get an expert opinion of another doctor, which points out to the negligence of the doctor against whom you are complaining. And then only that court can proceed further. There is a difference of opinion amongst lawyers, whether this provision is mandatory, is not mandatory, but a very recent judgment of the Honorable Supreme Court, we will discuss it in the later slide, has very clearly stated that this provision is mandatory. If the patient has gone to the criminal courts are bound to ask that patient to get a medical expert opinion first, and based on that opinion, then the court can proceed further. Let us now read the second protection, and this protection has been fantastic. Those of you who are senior, having practice of 25 years or more, would be knowing this. Earlier, the patient simply used to go to a police station, police used to come, and the doctor is arrested. But after 2005, stray incidents are happening here and there. Because of this protection which has been given, salutary protection, no doubt about it. Let us read, quoting, the investigating officer should, before proceeding against the doctor accused of rash or negligent act or omission, obtain an independent and competent medical opinion. The first aspect that has to be noted is that the Honorable Supreme Court has given this responsibility on the police officer, neither on the patient nor on the doctor. If you as a policeman think that the doctor has been negligent, then you have to obtain an opinion. The Honorable Supreme Court was very clear about what they wanted the policeman to do. And probably they also knew what the policeman can do when they are mischievous. So the Honorable Court tried to plug all these mischiefs by stating that you have to get an independent and competent medical opinion. And it is not from anyone. You have to get this opinion from a doctor in government hospital, qualified in that branch of medical practice. Sorry. Who can normally be expected to give an impartial and unbiased opinion applying Boland's law to the facts collected in the investigation, unquote. So the Supreme Court has said, you as a policeman, once the patient comes to you, files a complaint, You have to collect your medical record statement, whatever you collect in investigation. After that, take all that to a doctor. And it can't be any doctor. It has to be a doctor in government service. And that too, not any government doctor. It has to be a doctor who is of the same speciality as the doctor accused of negligence. And this doctor from whom you are taking an opinion, he should know Bolam's law. This is the most fundamental law about medical negligence. So he must understand what is negligence in the eyes of law, not in the eyes of a doctor or a patient or a common person. What is negligence in the eyes of law? He must know, he must apply that law to the facts that you have collected, and then he must give an opinion. Finding another doctor of the same speciality in a government setup and getting a report very early is a arduous task for the policeman. And possibly that was one of the reasons why the policemen wanted Dr. Archana Sharma to be booked, or rather they booked Dr. Archana Sharma under section 302. Because under section 304A, if negligence was there, this protection was not there. There was political pressure, there were other pressures. So, understand, the policeman has to obtain a written opinion from another doctor. Till then, no proceedings, nothing. Wherever the proceedings are there, they halt. You get enough time to vet advocates, to speak with them, to file legal proceedings, to take protections, everything under the sun, every legal provision which is there, you can use it. Such a wonderful protection. And friends, the last protection that they have given is, they have told the policeman, they have got an opinion, no problem. That opinion says the doctor is negligent, no problem. You have applied section 304A, no problem. Still, don't go and arrest the doctor in a routine manner. He is a doctor. You are charging him with negligence. We agree there is death. You have all the rights to investigate. You have all the rights to prosecute this doctor. But it is the courts who will ultimately decide whether this doctor is negligent or not. In the meanwhile, your biggest weapon, which threatens everyone and anyone, don't use it against the doctors in a routine manner. This is what the Supreme Court says. Let us read, quoting the Honorable Supreme Court, a doctor accused of rashness or negligence may not be arrested in a routine manner simply because a charge has been leveled against him, unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigation officer feels satisfied that the doctor proceeded against would not make himself available to face the prosecution unless arrested, the arrest may be withheld. Go to the court, let the trial start. Don't arrest the doctor. Friends, three fantastic protections for you. These are your rights given by the Honorable Supreme Court. You must be aware, you must exercise them. I am again not saying that, look, a threat of police station will not put you under stress, will not make you anxious. But there is no need to be unnecessarily anxious. Friends, the probability of you hitting someone with your car, a car accident, section 304 is applied there also, is 10,000, 20,000, 30,000 times more than causing death of a patient by negligence. Are you going to stop driving? Are you going to be under stress while driving? No. I do agree both the situations are different. And I have already said earlier, even if a lawyer practicing criminal law would have been called in the police station where personal charges are against the lawyer will also be under stress. But no undue stress. And with these three fantastic protections that you have, friends, please remember, these three rights, privileges, protections, whatever you call, are available to doctors only in cases of criminal medical negligence, not in any other crime. And it is available to all duly qualified doctors, no quacks, whether you practice modern medicine, whether you practice Ayush, or whether you are a dentist. How can you use this judgment? Patients, locals, attendants, relatives, they are threatening you. Have a copy in your drawer. Give it to them. Padh lo bhaiya, paragraph 53. Police tries to come and tries to teach you law. Says, sir, we understand what are your powers. You may do it. This is the copy of the judgment. Read it and then you are learned people. Go ahead. Let us not forget, this is not the law made by Parliament. This is the law made by the Honorable Supreme Court of India. And anyone who does not follow this law will be liable for contempt of court. Criminal contempt of court can also be initiated, although criminal contempt may not really stick. But civil contempt 100% will stick. 6 months imprisonment is there. So, friends, every doctor must have a copy of this judgment of the Honorable Supreme Court. Share it with your friends. Make them aware of this much fundamental law. And do not hesitate to produce it before police if they are acting illegally. Friends, so one question which obviously many of you would be having in your minds, fine, in 2005, the Honorable Supreme Court has given this judgment. What are the court's view today? Has it changed? And friends, let me tell you, the court's view have become more favorable towards doctors. It remains unchanged. Higher courts are taking very liberal view as far as negligence cases are concerned. I have already shared the cases which are there on the slide before you. Dr. Kunal Saha versus Dr. Sukumar Mukherjee. 2009, the Honorable Supreme Court is saying, and let us read it, quote, it is however well settled that so far as the negligence alleged to have been caused by medical practitioner is concerned, to constitute negligence, simple lack of care or an error of judgment is not sufficient. Negligence must be of a gross or a very high degree to amount to criminal negligence, something that we have already discussed in the first slide. Ordinary negligence, consumer code, civil code, if it's gross negligence, higher degree, recklessness, only then criminal medical negligence charges would be attracted. The second case, which I discussed with you a few slides back, a case reached the Supreme Court, private complaint filed by a patient in Bihar. And there one of the objections which was taken by the Supreme Court was, look here, the magistrate, he issued the summons or he started criminal proceedings without asking the patient to get a expert opinion. The Honorable Supreme Court sent back the matter to the trial court. You first get a medical opinion from a doctor. Ask the patient to get a medical opinion and then you can proceed against this doctor. I am quoting the Honorable Supreme Court. At the same time, it is noticeable that the trial court had summoned the private respondents. These were the doctors. Without insisting for medical evidence or examination of professional doctor by the complainant, this happens to be the patient. in support of his case made out in the complaint as required in terms of the exposition of this court in Jacob Matthews versus State of Punjab, the case that we have discussed, unquote. So friends, these are the views of the Honorable Supreme Court. Two pragmatic tips before we come down to an end of this session. Number one, as a doctor, please have good relationship with your local police, your beat officer. At times they may come asking for certain favors. Okay, check my BP, check my family members and my friends. Okay. But friends, with doctors, especially if you are a qualified doctor, you have done your MBBS, you are respected by not only doctors, by lawyers, by judges, by everyone. Have relationship with them. See, if a political pressure comes, if there is a higher officer whose relatives happen to be your patient and he wants to file a case, they will be under pressure. But trust me, they are going to help you. They will side you if you have excellent relationship with them. Nothing illegal. I am absolutely not talking about anything under the table. In a very legal way, they will help you. So have good relationship with them. In fact, this is of great help to doctors in today's era where violence is so very rampant. First sign of discontent, you feel that the patient party may be violent. You have a good policeman who knows you. Simple phone call, two policemen come and things start cooling down. And as far as associations are concerned, I will also make a request to Dr. Mishra that wherever ISCCM is having their units, city units, or I don't know what other units you have, you must engage a local lawyer who practices in your district, not High Court and Supreme Court lawyers. They will be of no help. The one who knows the police station, the one who knows how these things work in that district, you must engage, you must keep them empaneled. Whenever such problems come, you can take their help. Friends, this webinar was organized as already shared by Isha under the Dr. Archana Sharma MedLegal HelpDesk. ISCCM is a founding member of this HelpDesk. We give you legal advice, and we have been we have received certain calls, certain emails where doctors who have been threatened by policemen, they have called us. There are lawyers who have volunteered to offer you service. And mind you, all the services under this Dr. Archana Sharma MedLegal HelpDesk, they are absolutely free of cost. There is no cost to the doctor. Our effort is to ensure that at least in criminal cases, in police cases, doctors get the requisite help. So the first thing is we giving legal advice to doctors. If there is a need and there is a policeman on the other side, lawyers will speak from this helpdesk to those policemen, and they will guide you. If need, we will ensure that you file the proper legal proceedings also. The second aspect, the second initiative that we have taken under this helpdesk is we are training doctors who want to volunteer for the cause, who want to train their own doctor friends on the criminal medical negligence aspect. We will be sharing with you slide deck, we will be training you. In fact, we have held around 3 training sessions, and let me also thank Dr. Arun Sharma, who is here. He was amongst the very first who sent the email, I want to work for my community, I want to volunteer, and he was from the first batch who was trained by us. And now their email ID is there on the website. Anyone who wants to call them, webinars today, anyone can organize webinars. And to go to a webinar, it hardly takes an hour or so, nothing more than that. No preparation is required. And unlike CMEs and all, where physically traveling becomes a big problem. But anyway, these are volunteers who have been trained, who have the necessary resources, and they have taken it up to that they will train more and more of their colleagues. They will make them aware. Anyone who wants to become the trainer, so it's only doctors whom we are volunteering under this program. They can become volunteers and they can learn. Once or twice in a month, we hold this training session. You can simply write MedLegal HelpDesk at imlindia.com. Here you can write an email and we will get back to you on the next slot that is available. Any medical society, any hospital, any medical college, any doctors group, if you are a group of doctors, you want to hold a webinar, you want to hold a discussion session, please just write to us, or you can write to any of the trainers. We have put a list on the website. You can write to any of the trainers and we will try to hold that webinar, that training session for you. So friends, take you can take advantage of this help desk, and let us at least ensure that every doctor in this country is aware of this one legal right. This is what we want to achieve, and if together we work, we will certainly achieve it. Thank you, friends. Thank you for listening patiently. If there are any questions, I would be happy to answer.
Thank you, Bajpai.
Thank you, Advocate Bajpai, for enlightening us in such a lucid manner the criminal laws which are applicable to medical practice and how to use the salutary legal protection which is available for doctors. I would request, if you have any questions regarding this topic, please let me know so we can have the Q&A session.
Bajpai sir, I have a question.
Sure, go ahead.
Please go ahead. Arun, go ahead.
In an extreme situation, if an FIR is registered and the arrest proceedings are initiated, what should the doctors do? In an extreme situation, let's say under pressure from the bureaucracy, or let's say for any reason, what should I do as a medical practitioner? How do I save myself, or what are the procedures that I need to follow?
So if an FIR is registered, first thing that the police will do even before filing of the registrar, or it may do it after filing of the registrar, is they will come asking for your statement and you must give the statement. Okay. You have a right, Dr. Arun, to look into your medical records while giving statements. Okay. And don't bother about giving statements, because this statement is a trash before the court of law. Any statement given to the policeman is never taken up as an evidence. It only has corroborative value in rarest of rare cases. Otherwise, it has no value. So you should not fear. Give your statement. In fact, you must call your peers, senior ones. Okay, you can call your lawyers. Consult them. Give your statement. Number two, they may ask to, they may say, we want to search your premises. Permit them. You can't stop them. They have a right to search and seize. So they will search your premises. They may take away your, syringes and drugs which are kept open there, especially when a surgery has happened. Okay, they may seize it. Let them seize it. You have a right later on to approach the court and get it back from the court. This is the second thing. After this, you must go to your lawyers. You can very well go back home, sleep, and it is not that the next day they are going to file the charge sheet. They have filed an FIR. Now they are proceeding with investigation. I have already shared with you that they will now have to take all these medical records, all what they have collected in your premises, plus your statement, to another doctor in a government hospital, and wait for their expert opinion to come. Till then, they also cannot do anything. You must be knowing how government hospitals work. It is not that they go and the government hospital is going to give them, doctor practicing in a government hospital is going to give them opinion in 2 days. No. It is going to take months. By that time, you have enough time. You can speak with the policeman, you can speak with your lawyers, you can wait for the expert opinion to come. If there is nothing, then they will have to go and file a B summary. There is nothing beyond that. If not, they will file a charge sheet. You have to defend yourself, or you have to go in for quashing, revision, whatever it is there. Then that becomes a legal issue. See, Dr. Sharma, earlier, before 2005, what is it that was bothering the doctors a lot, or was a cause of concern, was what I have already shared with you. Patient simply gets up, goes to the police station, you are still in your hospital, police comes, arrests you, takes you away. That's all. That has stopped. That has stopped. So here, whatever they say, you have to cooperate. And after that, you have to approach your lawyers and whatever they advise, go ahead.
Right, sir. Thank you so much.
In fact, Dr. Arun, I think in the training session, this question must be added.
Sure.
Right?
That's right.
This
right.
would be, yeah. Well, I'll do the changes. Fine. Yes. Isha, you are not audible. Isha, you are not audible.
Do we have any more queries?
I think Dr. Mishra has to say something.
No, I don't have. Yeah, no question. Nothing.
Okay.
So can we conclude this session? I would like to give a vote of thanks on behalf of Institute of Medicine and Law to Dr. Rajesh Mishra, Dr. Arun Sharma, and the entire association of ISCCM. I request Dr. Mishra that the information regarding the help provided for Dr. Archana Sharma MedLegal HelpDesk should be sent to all the city and state chapters of ISCCM. So all the state and city chapters can officially nominate a doctor from their local chapter and benefit from this service. Thank you
Sure.
everyone.
Thank you.
For your time. Thank you.